All right, I see all the attendees clicking on over here. So thank you all for joining us for our first of 3 regulatory webinars from AHRI in the month of January. Today's webinar, Understanding the Congressional Review Act, or CRA, which you've probably heard us talk a lot about, and other exotic tools of Congress. On January 14th, a week from today, we're going to have a webinar on tariffs under the incoming administration. And then on January 9th, we're going to talk about PFAS and reporting requirements. So if you need any of that information for the additional 2 webinars this month, Lauren is going to put those links in the chat for you. So while you're listening to Scott and Joe today talk about CRA and other things Congress can do regarding rulemaking, you can also register for our tariff and our PFAS webinars. So with that, because I know Joe and Scott have a lot to talk about today, and I want to be able to have people ask questions as well, so you can always put your questions in the Q&A. You can text me, you can email me, and we'll get to as many questions as we possibly can today. So with that, Scott, I think Joe is going to kick us off with the Congressional Review Act, and then he'll hand it over to you. Does that sound about right?
Well, why don't it does, but why don't you let me just do a little level setting at the top, and then I'll hand it to Joe, and Joe, you take it from there.
Sounds good.
So the odd title that we've given this thing is sort of the Congressional Review Act and other exotic mechanisms, because we want to get you to be thinking in terms of the broad array of tools that Congress has at its disposal, or that the incoming administration also has at its disposal. So we're gonna start with some discussion of the Congressional Review Act that Joe's going to lead us off on. We're going to talk about the budget reconciliation process. We're going to talk about the use of appropriations riders. We'll talk about budgetary impoundment, something that if you are a student of the Doge and of Elon Musk, you might have heard that be in discussion. We'll talk about pauses in regulations, which are often ordered, at least for proposed regulations, when a new administration takes over as sort of a matter of regular order. We'll talk about options for executive orders and what can and cannot be done through an executive order. And then we'll talk about the use of administrative process, whether it's reopening the administrative process for a final order or the withdrawal of rules that are proposed. And we'll talk about the use of enforcement discretion and litigation strategies and the use of a creative use of settlement in order to get out of rules. So that is a lot to talk about, but I wanted to kind of level set a little bit. And the headliner, of course, is the Congressional Review Act. So let me turn it to Joe to tell you a little bit more about CRA. If you have questions, please do put them in the I guess it's the chat function, Mackenzie. I'm not really sure how we're doing
in the Q&A.
In the Q&A.
In the Q&A function.
In the Q&A section, and I know it'll be relayed to us, and we'll answer it, or we'll answer it in writing later. So, Joe, why don't you take over from now?
Great. Thanks, Scott. And hello, everybody. Good to talk to you today about the Congressional Review Act and other sort of interesting ways that Congress and the incoming administration can examine the sort of regulatory landscape of a previous administration. So the CRA, I think, is a very interesting sort of congressional oversight mechanism for regulations that has really kind of come into popularity, where we've seen this sort of ping-ponging between administrations of different political parties, and has really become quite a popular tool of Congress to first also sort of message their views toward certain regulations, but then also to utilize the authority that Congress was given under the CRA to actually withdraw certain regulations. So just to sort of quickly go over what the mechanisms are here of the CRA, a couple of sort of important things. One is that the CRA says that federal agencies need to report final rules to Congress. So that means that a federal agency, when they have published the rule in the Federal Register, must report that rule to Congress. Congress must have 60 legislative days to review that rule, and Congress can then decide whether or not they will take an action to disapprove of that regulation. Now, any single member of Congress can bring forward a Congressional Review Act petition, and there are sort of special procedures that allow the CRA petitions to proceed, that are sort of protected from the Senate filibuster, for example. And so both the House and the Senate do have to take up those resolutions and vote on them. If say the House passes one of these bills, then immediately goes over to the Senate, and the Senate has to vote on it. Now, where this really becomes, we've seen this used last Congress. Republicans to sort of voice their disapproval, or in some cases Democrats, right, like Senator Joe Manchin has used the CRA to show his disapproval of certain regulations as a messaging piece. That sort of Republicans were taking up these actions to show their disapproval of Biden regulations, but ultimately the president has to sign the disapproval motion into law in order for it to take effect. So therefore, when there's a divided government like that, it's not as useful. But what really does give the CRA its teeth is that is going back to that notion that Congress must have 60 legislative days to review a rule. So that means that if Congress does not have those 60 legislative days to review a rule, then that actually they get another chance to review such regulation beginning on January 15th of the next Congress. So that means that any regulations that are sort of finalized toward the end of a presidential administration, then the next Congress with the subsequent president can sort of have an additional chance to take an action to rescind that regulation. So you can imagine now that, and we think about it in the sort of current terms that we have, where the Biden administration has come to an end. There have been a number of regulations that have been finalized toward the end of that administration. I think we're sort of generally saying, if a rule was reported to Congress after August 1st, then that sort of falls within the not having had the previous Congress not having 60 legislative days to review it, and therefore that sort of 60-day clock will start again on January 15th of this Congress, which then allows, now that we have the trifecta, the unified government of Republican House, Senate, and executive branch, that the Congress can take up one of these disapproval motions. It theoretically will pass the House and the Senate, and would be signed by the president to actually rescind that Biden administration era regulation. And a couple of sort of interesting points to say about this is that, yes, in fact, when the CRA action happens, the rule essentially goes off the books. It is not implemented. The CRA also says that the federal agency cannot promulgate a rule in the substantially similar form. You may also have seen that referred to as a substantially similar rule, and so that is an important factor here, because particularly in instances where the CRA has been utilized to rescind a regulation that actually Congress told the federal agency to promulgate via statute, it does create this sort of, in some ways, a crisis or an issue, where Congress disapproves of a regulation that Congress, in fact, told the federal agency to write. And so when that has happened a couple of times, and so federal agencies will usually go back. They will examine sort of the legislative history of that statute and attempt to put forward a different regulation that is not in sort of a substantially similar form. And the way that the Congressional Review Act was written is that really it's up to Congress to determine if that regulation is in substantially similar form. That means that Congress ought to utilize the CRA again on that regulation when it's their view that that rule is not in substantially similar form. There have been a couple of times where some petitioners have challenged some of these sort of subsequent regulations in court, attempting to utilize the Congressional Review Act as a sort of a judicial mechanism. And in fact, courts have said, the CRA is not something that we are going to weigh in on. It's a power of Congress that Congress bestowed upon itself, and it's really up to Congress to determine whether or not that regulation has been the replacement regulation is in substantially similar form. So it's a very, as you can see, the CRA is a very powerful tool when there is this unified government situation that follows an administration of an opposition party. And just to kind of go over some general sort of facts and figures, when the Trump administration came in 2017, you'll recall certainly not many people were giving Trump a chance to be president, and so the Obama administration had not really taken as seriously the Congressional Review Act, and I think the Trump administration with the unified Republican Congress overturned, I think it's somewhere about 13 to 15 regulations, and that when the Biden administration took over after Trump, there were a number of regulations that Biden and the Democrat unified government pulled back, and we can, I think, certainly anticipate that there are a number of regulations here that will be taken a hard look at by the Congress and attempted to take this action through the CRA to pull those regulations back. Scott, it looks like you want to say something here.
Yeah, I just wanted to add a couple things for people to think about. The CRA, as Joe was describing, in conditions of unified government can be a very effective tool, but it also is a very blunt instrument in a lot of ways. And Joe got into that when he talked about sort of eliminating the potential for substantially similar rules to replace the rule in question. And I think for HRI, that has two important implications. There's maybe many implications, but one of them is this. Sometimes we oppose portions of rules, parts of interpretations, definitional questions, things like that. But the architecture of the rule itself is something that may be okay, in fact, may be desired for purposes of giving a direction for investment or things like that. In situations like that, CRA is not a very good tool, because the actual terms of a CRA resolution of disapproval is set out by the statute. So you can't disapprove part of a rule and keep the rest of the rule in place. And so you do run the risk that those parts of a rule or a regulatory program that you might be supportive of would also be swept away, and you would have a great deal of difficulty in structuring something to replace it. So before you support a CRA petition, you have to be very sure that you've locked down the law of unintended consequences. One other thing about unintended consequences. Some statutes, EPCA would be one of those statutes, but there are others, have a broad theory of preemption of state action. And that theory is based essentially on statutorily embraced what's called field preemption, which means that the government, the federal government, has chosen to comprehensively regulate a subject matter, and therefore state actions that are inconsistent, unless they are pursuant to particular grants of state authority would arguably be preempted. One thing is, if you take rules and you subject them to a CRA petition, it sort of blows holes in what would otherwise be field preemption, because you're saying the field doesn't apply to that one particular area that the CRA petition would remove. And so you have to consider that too, if there is a question regarding preemption versus versus a less than optimal federal regulation. It may be that a less than optimal federal regulation is preferable to states running amok. So those are just the law of unintended consequences that can flow from CRA, because CRA is a blunt instrument and it was designed to be. It was not designed to be a mechanism to carefully edit rules. That it is not. It's not the CRISPR of rules. It's in fact the fungicide and rodenticide of rules. So okay, that's all what I wanted to add, Joe.
Great, thanks, Scott. Yeah, so I think just to as a sort of final point on CRA and sort of how we anticipate the CRA to sort of play out here in the 119th Congress and the Trump administration. As I said, I think we're aware that the congressional committees are sort of combing through and have been combing through regulations that have been finalized sort of August 1st onward. And sort of compiling lists of potential regulations that they may want to utilize the Congressional Review Act on. I think that the Republican leaders in Congress are very prepared to pull back Biden administration regulations, and that they sort of view the Congressional Review Act as part of their oversight toolbox, and in some cases may not have truly kind of thought out what some of the implications are with the substantially similar provisions in the CRA, and are sort of maybe more prepared to sort of just do this for politically expedient purposes, and I think that also that we can anticipate sort of the Trump administration and congressional Republicans to be thinking creatively about sort of how they can expand some of their authority under the Congressional Review Act. You may see certain Biden administration activities be submitted to Congress as rules that by the Trump administration that historically have not been considered rules previously, and I think that this is certainly an area where the Republicans think that they can expand some of their sort of regulatory rollback tools for sure. And then the last thing I would just say is that the CRA, compared to some of the other things that we're going to discuss, is relatively a quick process. I mean, Scott is 100% correct that this is a blunt instrument, right? This is a rescind the rule and limit the ability to replace it. There's not, again, the courts don't really get involved in sort of the decision making on the CRA. And as you'll see in some of the other things that we'll discuss that follow sort of what we're more familiar with, the Administrative Procedure Act rulemaking of taking comment and sort of reviewing the record and things of that nature, that doesn't really go on here. This is sort of one single member brings forward a CRA action, it passes the House, it goes over to the Senate votes on it, or vice versa, and then it can get signed by the president, and that rule doesn't exist. So again, it's something that it can happen fairly quickly without a lot of intervening activity from outside stakeholder groups, aside from advocacy. So yeah, I think that's what I've got to say about CRA. And if you have questions, just let us know. Otherwise, I think we'll keep on chugging forward. Go ahead, Scott.
Okay, well, so I'll pick up next on on two other items: budget reconciliation as a process for addressing regulatory issues or programs, and appropriations riders. And these two things are related because they both attempt to refrain from what's called legislation in a budget or appropriations context, but often end up doing just that. So let's talk about that. Of course, you're familiar with the budget reconciliation process because that's the way the Inflation Reduction Act was adopted, hook, line, and sinker. Budget reconciliation allows Congress essentially to pass budget-related legislation with a simple majority. So it avoids, it bypasses the potential for a filibuster or the need to invoke cloture is the technical term for that. But you don't need a supermajority as you do with much other forms of controversial legislation. And while it's primarily was intended and was developed as a mechanism to deal with fiscal matters, it has been used to address regulations that directly impact federal revenues, expenditures, or the debt limit itself. Now, I'm often asked the question, some of you may have this question, which is, well, let's say there's a regulation we don't like, a regulatory program we don't like. Could we use budget reconciliation to change the terms of that particular regulation or to eliminate a regulation in its entirety? The general answer to that is no, because of something called the Byrd Rule. The Byrd Rule is a test that is in the United States Senate that is applied to potential additions to budget reconciliation by the Senate parliamentarian to determine if those provisions are sufficiently related to the budget. So are they truly fiscal matters, or is their impact on fiscal concerns, either raising taxes, lowering taxes, or changing government spending in some profound way, are those merely incidental? That's the phrase that's used. Are they merely incidental? So you may say, well, why are we even having this discussion? Well, let's say you wanted to have expedited consideration by the Department of Energy to determine whether or not a particular device met an efficiency rulemaking. I have often been asked the question, what if the regulated community, what if an AHRA member agreed to pay the federal government for an expedited consideration in a situation like that? And by the way, that's not such a crazy idea because many parts of the federal government do operate off of user fees and things like that. So what if you agreed to pay a particular price in order to have expedited consideration for regulatory outcome? Wouldn't that then convert this proposal, this program, into a revenue raiser, and therefore wouldn't it meet the Byrd Rule? And the answer to that is no. The part that actually raises the money might survive the test of the Byrd Rule, might not be merely incidental. But the part that gave you the regulatory reform or gave you the change in regulatory treatment would not in and of itself raise the money, and therefore would likely be outside or in violation of the Byrd Rule, and therefore would be outside of what would be acceptable under reconciliation, which leads to weird outcomes, like you having the ability to pay the federal government money, but not being sure what you get in return. And so that's why as a general proposition, you saw this most recently in a statement that Congressman Bruce Westerman made about whether or not to try and stick regulatory reform or permitting reform into the reconciliation bill. And he said, no, I don't think it'll make it. And the reason he thought it wouldn't make it is because the part that raised the revenue would be okay under the Byrd Rule. The part that gave you the regulatory reform or the expedited permitting would not be. And that's just an inappropriate use. Now, you might say, well, a parliamentarian, that doesn't sound like a very important job. Can't they just overrule her? In this case, it's a woman. Can't they? Couldn't they just overrule her? And the answer is yes. A simple majority can overrule the parliamentarian. But here's the problem with that: if they choose to overrule the parliamentarian, then the budget reconciliation, the entire bill, loses its privileged status and therefore can be filibustered. So if you overrule the parliamentarian, it's like kissing your sister. I mean, that's not, it may feel good while you're doing it, but the truth of the matter is, I can't believe I'm going down this path. So let me just let me just withdraw that. Let me just withdraw that and say you really can't do it. And in fact, most regulatory reforms are withdrawn from budget reconciliation before it ever gets to the point where you have to overrule the parliamentarian. Appropriation riders, a little bit different. You know, in the olden days, as Samantha knows, we used to pass the 13 annual appropriations bills that constituted the roadmap for government spending for the upcoming year, just that single year, the next fiscal year, right? And one thing that we could do in an appropriations context is prohibit a government agency from undertaking a particular regulation, at least for the pendency of that upcoming year. Because remember, an appropriations rider, just like an appropriations bill, only lasts 1 year. Okay, so that would be the concept. There is another form of, sometimes also called the Byrd Rule, another rule of a parliamentary objection that can be raised, which basically says that you cannot legislate on an appropriations bill, which means you can't just stick unrelated legislation onto an appropriations bill. So then how does a rider work? A rider uses the negative power of appropriations. So rather than saying the EPA can't do, or rather than saying, for example, the new EPA rule under the Water Sense program has to look like X, Y, or Z, instead a rider is phrased in the negative. No money appropriated under this standard can be used for the implementation, enforcement, or finalization, implementation, or enforcement of the rule that was published at 59 Fed Reg 2126, right? That is what an appropriations rider looks like. So it uses the negative power appropriations. Thou shalt not spend, not thou shalt spend on a rule. So just like the problem Joe and I were talking about with respect to a CRA petition, an appropriations rider has that limitation too, which is if you like part of a rule, right, and you want to change another part of the rule, you can't really use a rider to do that, because the part that changes the existing rule would not survive the parliamentary objection. The part that eliminates the enforcement and implementation of the rule from the get-go, that would pass, because that is the negative power of appropriations. So appropriations riders, you know, I once did a count of the number of appropriations riders that I've written at one time or another, and I think it's in the 20s. So we can do it. Now, all 20 of those were not adopted, but probably a good 5 of them have been adopted over the years. And when it happens, it's a big deal. It works best if the other side doesn't know you're doing it. That's when it really works the best. And that's increasingly harder to do these days. Another kind of budgetary rare bird is the use of budgetary impoundment to defund a regulatory program. What does this mean? Well, this means we have a budget of the DOE, okay? And part of the budget of the DOE is the part of the budget that funds up energy efficiency and renewable energy, right? The Congress has the power of the purse, so it set what the budget is for EERE. The president looks at that budget for EERE and he says, oh boy, there's too much money being spent on these efficiency regulations, particularly the ones on X, Y, or Z products. I don't want the money spent on that. I want to take that money that would be spent on that and I want to spend it on something else. It could be some other part of the DOE's budget, or it could be some other part of government entirely. Once the Congress authorizes that money to be spent, can the president just change based on his sort of whim where the money is spent? Well, if you ask Elon Musk that question, who is one of the finest South African experts on U.S. Constitutional law, he will tell you, yes, that does sound like something the president can do. Unfortunately, at least since the Nixon administration and the adoption of the Anti-Impoundment Act, that is not something the federal government, the executive branch can do, unless they get the permission of Congress to do it. And they do have an expedited way to get the permission of Congress. But if Congress does not give that permission, if Congress says nothing or says no, then the answer is no. They have to spend the money on what it is for. Okay? If Congress says yes, then it's approved, and they can use on this expedited basis. They can use impoundment authority. Why am I even talking to you about this? Talk about rare birds. I mean, this is like never done. Why? Because it's something that Elon Musk and Vivek Ramaswamy have put in play by suggesting that it could be a source of authority to implement the recommendations of the Department of Governmental Efficiency, or the DOGE. So we have to keep a look at it. But it will require Congress to act in order to implement that strategy. There are some lawyers out there who are very pro-imperial presidencies, who believe that perhaps the anti-impoundment language in the Budget Act of '74 is unconstitutional because it's too much of an infringement on the president's power. But there's a reason why Article 1 of the Constitution, the part that sets up Congress, comes first. And that's because Congress has an untrammeled power of the purse. They get to decide how money is spent, not the executive branch. So I suspect the worst side of the argument is that the Budget Act of '74 is somehow unconstitutional. So I don't see a lot of play in the joints for impoundment. There are no free lunches. There are no easy approaches. And the DOGE will probably have to learn that the hard way. But nonetheless, this is one of their sources of authority that they're looking at. So,
Mr. Siegel, we have a question before you leave impoundment, if you don't mind. What is the process for congressional approval of a request under the Impoundment Act? Does it require overcoming the filibuster? Everybody loves the filibuster.
Right. It is not a privileged motion, so it does require Congress to act without privilege. Which means no, it does not overcome the need for a supermajority.
60 votes it is.
Right. Or not. I mean, look, if the DOGE is smart, all right, and they make smart recommendations, the recommendations they will make, they'll make some recommendations that there's no way they're going to be adopted, and they'll make others that are very focused. And ones that are very focused, look, we have believe it or not, there still are Democrats who will vote against government regulations. And so it wasn't all about Joe Manchin. You know, there are people who will do that. And they'll need to be careful about what they ask for.
Yeah.
Now, the next rare bird on our list goes back to my friend Joe, who's going to tell you what it's like when there's a change in government administrations and you hear the president has decided to push the regulatory pause button. What does that mean?
Thanks, Scott. And I think this sort of the regulatory pause and transition periods fits kind of nicely after the impoundment discussion, because I think Scott and I are getting a lot of questions about what this incoming administration will do, particularly with a lot of the programs at the Department of Energy, because of the sort of the large amount of grants and loans and spending projects that have occurred at the DOE that may sort of not have a regulatory function, but certainly have a programmatic function. And I think what we'll see here, which is similar to regulations, is that there will be some kind of pause in moving forward with both sort of the spending programs, whether that's the loan program office or the grant making office, which does sort of dovetail in with, it's not necessarily impounding the funds, but it's, the administration saying, well, we need to take a look at our portfolio here. We need to understand, sort of what sort of various loans have been given or what kind of grants there are, and decide how best to administer that moving forward. It's very similar, I think, on the regulatory side, in that and this I think has a precedent in nearly all incoming in presidential administrations, is that the new administration will come in, they will say, we're gonna impose a freeze on any regulations that are pending, and that may happen sort of at the agency level. There could be an executive order on that, and Scott will get into that in the next round of discussion here. But this essentially, what this will do is it prevents any pending rules from being finalized until they are reviewed by the new administration. So what does that mean when we say pending rules? So there are rules that are probably still in the either in the pre-proposal stage or in the proposal stage. So this will apply to rules that the agency might just be sort of they're working on something, but they're working on a proposed rule, but they haven't released the proposed rule yet, or in fact they have put out the proposed rule and they're either accepting comments on it or reviewing comments, or in sort of the post review comments, or sort of working towards a final rule. That those rules will all be paused, they'll be frozen, and then also applies to any rules that are essentially not yet published in the Federal Register. So even if they're working on writing the final rule, for example, but they haven't completed it, this does give that the new administration the chance to sort of review what's been going on and realign those regulations or rulemakings with the policy of the incoming administration. I think the thing that it's sort of important to note here is that this does also apply to rules that may have been finalized but not necessarily published in the Federal Register. Sometimes you'll hear that these rules are sometimes referred to as midnight regulations. These rules that are essentially finalized but maybe not yet published. The incoming administration does have the ability to try to sort of pull those back before they're published, before they become effective, so you can imagine that to the extent that the Biden administration has any of these rules that they're trying to push out and publish as quickly as they can, that they will be trying to move that along in an expeditious fashion, and very well. Some of those rules that just to sort of circle back to what we originally talked about, right? Any rule that's published in the Federal Register now and reported to Congress then would be subject to the Congressional Review Act. A couple of important things to just note here. So rules that are already finalized and effective are not subject to these pauses, and so that would be rules that would be examined either under the CRA or we'll talk about later, sort of utilizing the APA process to go back and look at some of these rules. And there is the possibility that these pauses lead to some legal challenges if they're sort of the delay here is arbitrary or unjustified, and there may be ways to sort of force the agency's hand and moving forward. But that is what we can anticipate when Trump comes in, is telling all federal agencies to sort of put the pens down. Let's reevaluate what we're working on in the regulatory sector, and then sort of align priorities and move forward from there. Scott, on to you for executive orders.
Sure. And by the way, I'm now going to correct my statement about whether or not these motions are privileged under the rescission and impoundment. I'm right. They are not privileged. They go regular order. They're referred to committees. But if a committee were not to act within 25 days of continuous session, then they can be discharged, and the motion to discharge is privileged, but it will not be honored unless 1/5 of the body in question signs on to sponsor the motion for rescission. The motion for discharge. So it's a little bit more complicated. It still would be a hassle and a half to get it expeditiously to the floor. And we can that's what I would call 301 level. We can talk more about that.
Yeah.
Later. But it also goes to show you how infrequently this procedure is used. I do want to talk about executive orders, and I just want to remind you of this. Executive orders, particularly at the beginning of administration, are incredibly popular because a president can just whether you're talking Donald Trump or Joe Biden, they can just, put pen to paper and write an executive order, and it's printed in the Federal Register, and by golly, it's assigned a number, and there you have it. But the problem with an executive order is it can't it cannot change an underlying statutory obligation. So let's say you have a regulation, all right, and a regulation exists because it is an implementation of a statute, right? So efficiency regulation, statute, EPCA, right? The president can't, in an executive order, repeal a regulation, which is an instrumentality of that statute, because it can't change the statute. What he can do is a couple of different things. The president may instruct the Secretary of Energy or the Administrator of EPA to begin the process of changing a rule, and Joe is going to talk about how that works in a moment. But he cannot, in and of himself, through an executive order, without the participation of the Congress or without notice and comment rulemaking of the sort that one would find under the Administrative Procedure Act, cannot make that change merely by executive order. The Trump administration found out about that the hard way in a series of lawsuits at the beginning of the Trump administration. So anyway, that's a word to the wise. There are going to be, ladies and gentlemen, a whole lot of executive orders on day one of this administration. The administration plans to issue at least 25 executive orders on day one, with additional orders following throughout the following days and weeks, with a total of probably 70 to 75 executive orders. This is what we've heard. Obviously, you can mix and match. You could have different parts come together, or they could separate them apart for whatever reason. The reason to separate them out into different executive orders is to give every policy that you announce its little day in the sunshine and allow it to proceed. Now, what are we anticipating in our neck of the woods as far as executive orders on day one? There will be a lot of executive orders a day one or in this first period that will deal with fossil fuel production and exports of fossil fuels. As you well know, the president's talked about directing federal agencies to expedite drilling on federal land. Federal land is much more under the purview of the executive branch, so it doesn't require a change in the statute, in an underlying statute, except in some rare situations like reversing a withdrawal of offshore exports, of offshore drilling, which we can talk about later. In our neck of the woods, environmental regulation, there's no doubt the president's going to initiate a withdrawal from the Paris Agreement. That internal discussion is already well underway. No doubt that he will direct federal agencies, just as I've said, to revise Biden-era climate regulations. How wide an aperture the definition of that is, but particularly those that affect power plants and vehicle emissions are expected on day one. He's likely to reinstate what was called the 1 in, 2 out policy. Any new regulation that a government agency announces, they have to repeal two existing regulations. And on and on. There are many others dealing with clean energy, dealing with electric vehicles. Will they do a day one statement regarding DOE energy efficiency or about particular products to which such regulations apply? I doubt it. But would that be later later? Perhaps they would do so. But again, all they can really do is instruct cabinet official to begin the process. And Joe, why don't you talk a little bit about that process, particularly with respect to final rules that would have to be reopened?
Yeah, happy to. Thanks, Scott. And so I think one of the things that I think has been made very clear by both the president-elect as well as the folks that he has nominated to be in his cabinet for the sort of energy and environment positions is that they do intend to take a very broad look at the Biden administration regulatory agenda. That is the sort of already finalized rules that are not applicable, that they cannot sort of rescind through any of the other mechanisms that we've discussed today, and sort of do so by utilizing the administrative process to to rescind and replace these regulations. And just to be clear, I mean, any president can undertake these actions at any time, and it is sort of utilizing the current Administrative Procedure Act process to take a sort of hard look at a rule that's on the books, a final rule, and sort of use the notice and comment process to rescind that rule. So that's sort of building. They'll have to examine the rule. They have to build a record, and whether that's sort of saying that a certain rule that wasn't relying on the best available science, that there was other additional information that was available, that and that the rule may have run afoul of sort of legal authority of the agency. These are the kinds of things that they might discuss in some of the rescind proposals. Put out that proposal for notice and comment, receive those comments, and then sort of finalize the rescind and then replace that regulation with another rule. And we saw this quite frequently in the first Trump administration, particularly at EPA, where they were examining a number of regulations like the Water of the United States rule, the Clean Power Plan, others, where this was utilized quite frequently. Now, a couple of things to say about this. This process is time consuming, and it is sort of cumbersome because you are sort of boxed in by the APA, and so what if you're sort of making playing fast and loose with the sort of framework there. I think there's a lot of potential for litigation around this decision making, and so I think it's fair to say that sort of repeal and replace of a very sort of consequential rule probably takes somewhere on the order of a year and a half, and that's a lot of time, a lot of staff time that could be devoted to other regulations, other policies within sort of the various program areas, if we're talking about EPA, for example. So this does have a lot of work that goes behind it. And then I think this is also an important time just to note that to the extent that that there have been a number of important Supreme Court decisions about talking about what a federal agency's authority is to utilize deference, that is to sort of what kind of deference a federal agency has to interpret the statutes written by Congress that they promulgate their regulations based on. And while Scott will tell us that the EPA claims they have not relied on Chevron deference for some time in a number of their rulemakings, I think it is certainly possible that when an agency is trying to rescind rules or repeal rules and sort of that in some ways the Loper-Bright decision and these other decisions that have come out of the Supreme Court recently might actually limit the ability of a federal agency to say in any instance where they are relying on discretion to take these actions, it may sort of box them in from litigation challenges. So we certainly anticipate a number of these actions happening, as Scott said, particularly out of EPA when it comes to the power plant rules, emissions rules for both mobile sources and stationary sources, and other potential regulations out of other agencies as well. So this is kind of the standard way of doing business, of putting forward a regulatory agenda that aligns with the president's vision. And then just the next point that I will talk about quickly here, and we did sort of discuss this already briefly, is that we do anticipate that the incoming administration will withdraw proposed rules, and so that's again rules that have not yet been finalized. The new administration can certainly withdraw them without having to undergo any sort of formal rulemaking, and they simply just need to provide a reasonable justification for that. And so again, this gives the administration the sort of ability to either choose whether or not to sort of re-propose those rules or sort of attempt to sort of take them in a different direction. And so we will certainly, I think, see that happening here in this administration, and I think that it's possible that, again, the executive orders that Scott was talking about will direct the agencies to take some of these steps, or that sort of the heads and political appointees at these agencies will sort of be taking these actions on their own as well. And then so that does sort of lead into the next discussion, which is another way that this administration can kind of do some regulatory reform is in the sort of enforcement discretion space. And so that's sort of choosing how an agency goes about enforcing its regulations. And you often see this at the EPA, for example, in out of their the OWECA office, the enforcement office, is that they set, and every administration does this, and they set out their enforcement priorities. They say, these are the 5 areas that we intend to really sort of prioritize nationally. That's what we'll tell the regional offices to go out and sort of be as astute as possible about enforcing, as it's a priority of the administration. And then what that does is it prioritizes certain actions, but then it does deprioritize with sort of lower risk issues that are may not be as sort of a priority of the administration. So this does provide immediate relief to regulated entities. Of course, they're still regulated, but they're just sort of the enforcement is done in a slightly different way. But again, there's always risks here in that sort of there's a perception of maybe there's a sort of regulatory inconsistency or favoritism that's being given to certain industries when this is undertaken. And then, of course, there's sort of the criticism and backlash that certain stakeholder groups will take toward what would be the priorities of the administration. And you can imagine if say the Trump administration says, well, we're not going to we're going to deprioritize sort of our views on climate emissions enforcement, then NGOs and other groups will sort of be pushing back in the public sphere on that, and there may, of course, be sort of litigation concerns about how that sort of transpires.
Yeah,
Scott.
So, yeah, and on enforcement discretion, I sometimes think of it as the great booby prize of regulatory reform, because they just say, well, we just won't enforce against you right now on this, but every one of the environmental program statutes that you're familiar with has a private attorney general or citizen suit provision, sometimes called, which allows a citizens group to act as if it were the attorney general. And the case law is not great on whether an enforcement discretion letter defeats a citizen suit. There's case law both ways, actually. So it's not as any of your general counsels can tell you, it's not the favorite outcome for fixing a regulation. But speaking of litigation, the last thing we wanted to remark is obviously a lot of rules are still under litigation, final rules under litigation. You have to have a final agency action before you can litigate against the rule. But it is possible, as the Trump administration takes over these litigation dockets, that they may settle these litigation on terms that are favorable to the litigant. Now they can't be particularly obvious about doing it that way. They have to have a reasoned legal rationale to do it, because if it looks obvious, courts will set aside so-called brother-in-law deals, as they're sometimes called, if a settlement is on terms that are clearly favorable to the litigant for no good reason. So they have to be careful in doing it, but this is something, the litigation docket is something, every one of these cases is going to be in abeyance until the Trump administration can take over the docket and make and call balls and strikes on that docket. So now a lot of people ask me sometimes, why should we sue the Trump administration if they're supposed to agree with us anyway? And that is because you set up a situation where they may be able to reach a favorable settlement.
Yeah.
We're at the top of the hour now. And Joe, I think do we have to go?
We do have to, unfortunately, we do have to jump right at 2.
Right. So Joe, okay. So Samantha, that's it. We said we would cover 10 items. We covered 10 items.
You did.
Yeah. So,
thank you guys very, very much, Scott and Joe. We will see maybe Scott back on our tariff call on next Tuesday, the 14th. So we will see you all there. This webinar was recorded. It will be behind the members only paywall. So if you need to find it later, just let us know and we'll direct you there. But Scott and Joe, thank you again. We appreciate it. Informative as always. And we are likely, just so members know, as the Trump administration kicks off and issues come up, I think perhaps the 1 in, 2 out could be an interesting topic to discuss further, as well as deregulation topics, as Scott and I have talked about a lot over the last few weeks, to do webinars on later. So stay tuned for more. Thank you guys. We'll let you run off. And thank you, Lauren and Mackenzie, for all your work in getting us set up here today. And we'll see everybody next week. Thank you, guys.
Bye-bye.